High courts. High court stands at the head of the state's judicial administration. There are 25 high courts in the country, 3 having jurisdiction over more than one state. Among the union territories, UTs, Delhi has its own high court, while Jammu and Kashmir and Ladakh have a common high court, with principal seat at Jammu in winter and Srinagar in summer. Other UTs come under the jurisdiction of different state high courts. Each high court comprises a chief justice and such other judges as the president may, from time to time, appoint. The chief justice of a high court is appointed by the president in consultation with the chief justice of India and the governor of the state. The procedure for appointing the high court judges is the same, except that the recommendation for the appointment of judges in the high court is initiated by the chief justice of the high court concerned. They hold office up to 62 years of age. To be eligible for appointment as a judge, one must be a citizen of India and should have held a judicial office in India for 10 years, or must have practiced as an advocate of a high court or two or more such courts in succession for a similar period. Judiciary. At the apex of the entire judicial system exists the Supreme Court of India, with a high court for each state or group of states, and under the high courts there is a hierarchy of subordinate courts. Panchayat courts also function in some states under various names like Nyaya Panchayat, Panchayat Adalat, Gram Kachehari, etc. To decide civil and criminal disputes of petty and local nature, different state laws provide for jurisdiction of these courts. The High Court in each district is that of a district and sessions judge. This district court is the principal court of civil jurisdiction and can try all offences, including those punishable with death. He is the highest judicial authority in a district. Below him, there are courts of civil jurisdiction known in different states as municipes, subjudges, civil judges, and like. Similarly, criminal courts comprise chief judicial magistrate and judicial magistrate of first and second class. Enactment of law. The Parliament is competent to make laws on matters enumerated in the Union list. State legislatures are competent to make laws on matters enumerated in the state list. The Parliament alone has power to make laws on matters not included in the state list or concurrent list. On matters enumerated in the concurrent list, laws can be made by both the Parliament and the state legislature. But even in the event of repugnancy, law made by the Parliament shall prevail over law made by state legislature. To the extent of repugnancy be void unless the latter law, having been reserved for consideration of President, has received his assent, and in that event shall prevail in that state. This is all about enactment of law, judiciary, and high court.